Is Muslim personal law the last word, or is a relook possible? Our panel this evening, we have Zafaryab Jilani, he's member of the All India Muslim Personal Law Board. In studio, we have Atiya Zaidi, she's an educationist and publisher. We also have Zakia Soman, she's the founder of the Bharatiya Muslim Mahila Andolan. We also have Professor Tahir Mahmood, he's a former member of the Law Commission of India. If I can start with you, Atiya, you've been writing a lot about this today. What agitates you about this particular case?
This particular case, or thousands of girls getting married off on Akshaya Tritiya, I mean, this country has known child marriage since ancient times. So that is something which really agitates me, because I take it as a case of child abuse.
So you're saying that even it's not because I'm a Muslim that I'm...
No, not... I mean, this is a...
That you're perturbed about what's happening to girls in your community. You're saying...
No, I'm perturbed about what's happening to girls in general. Girls who are 13, 14, 11, 12, I mean, we can't just, they are not developed physically, they are not developed emotionally, they are not mature enough. Even the law doesn't recognize them. They are not allowed to vote to choose their leader. How can they choose their life partner and their life course?
But do you accept that perhaps a lot more of this is happening within the Muslim community?
I don't think so.
Okay.
I think it's happening in the rural poor. So that's irrespective of religion, because if you go to these on like I said, Akshaya Tritiya, or in Rajasthan, Madhya Pradesh, UP, in these places, there's a lot of Chhattisgarh, a lot of child marriages. So in the rural areas, there aren't that many Muslims in North India.
Okay. Zakia Soman, the court has cited various other precedents. They've gone by Supreme Court rulings, they cited the personal law. And even though, you know, when we spoke to other lawyers, while they said yes, this seems to be contradictory with other various like the criminal code and things like that, but they're saying it's also there is a Muslim personal law. Could the judge have done something differently?
First of all, I have to say that this is a huge setback to the efforts of thousands of Muslim women across the country who are demanding justice and fairness as given in the Quran. So it's a huge setback. And it also resorts to a very narrow and restrictive definition of puberty. What is puberty for a girl? It's not just attainment of certain physical attributes. It is her capacity to be able to decide for herself. We are talking about emotional maturity, we are talking about mental maturity. And you cannot marry off a 15-year-old child and say that this is valid because it is valid as per the Muslim personal law. I'm sorry, it's not valid as per the Muslim personal law. In India, we do not have a Muslim personal law in a codified form.
Okay.
So whatever are the popular prevalent practices, most often based on misinformation, lack of information, and based on patriarchy, they get passed off as personal laws.
You're saying it's everyone's interpretation of it.
It's everyone's interpretation, which is utterly faulty, and it is violative of the principles of Quran, and it's totally un-Islamic to call them personal laws.
Okay, you're getting into larger issues, but I just want to specifically come back to this case. Instead of citing these other judgments and this thing, what could the judge have said?
Yes. See, this judgment is is counting on the Mohammedan law. Now, what is it that we understand by Mohammedan law? These are all laws based on practices in the British era. It's not a law which has been sort of put together by the Muslim community, leave alone the Muslim women, and passed by the Indian Parliament. There is no such Muslim personal law exists.
Okay, let me just get that straight. Perhaps Professor Tahir Mahmood will be able to explain, being from the legal community and member of the Law Commission of India. Here we have Zakia Soman saying, why is it that he refers to this law which is not codified? When does the law, when do judges, and this is of the Delhi High Court, refer to the Muslim personal law? And should they have in this case?
The judgment of the Delhi High Court is absolutely right. There could not have been any other judgment, and it is unnecessarily being attributed to Muslim personal law. If this girl had been a Hindu, the judgment would have been the same, because it is because of the country's law. The marriage of a minor girl or boy by the law of India is not void. It is only a penal offence. And so those who are responsible for it, they can be prosecuted. But so far as the validity of marriage is concerned, Indian law is very clear.
Okay.
It is uniform for everybody.
Do you have the NDTV Profit app? All the markets, all the news and your own homemade, ready-made portfolio available there for you.
We will right now answer what you should sell, what you should buy when markets are down.
Download at ndtvprofit.com/apps. Get the best app from the channel you trust.